Well, I don't know what the Latin word means, though.
Two different topics, and we'll try and split our time in half. The first would be relating to conflicts of interest and the legal ethics of multiple-party representation. And the second would be the duty to report professional misconduct. And I think either one of these might take an hour or more to actually do thoroughly, but I think we can hit some of the highlights, and we'll kind of go through that together and see what we come up with. So let's get started. With regard to multiple representation of parties, this is our agenda. I want to talk, I think, in some detail about the model that we have in Rule 1.7 regarding how we analyze and work through conflicts of interest. And as we deal with multiple party representations, we're always talking about that potential. Certainly, any time the lawyer receives representation or an offer to represent the second client, there's always a potential conflict. And the truth is, a lawyer could have a conflict of interest even though there's only one client involved in a matter at all because of the lawyer's own personal interest. But one of the good things about our rule in Wisconsin, which is based on the model rule, and it's very similar to it, very few differences, is that the comments that we have in the ABA comments are very, very helpful in guiding us through the interpretation of the rule and how it would apply to the situation that presents itself in our practice. So comment 2 talks about a model for analyzing that. We're going to go through that in some detail and then look at some cases applying that. A couple other the topics we have are here. We'll also think about those specific situations where we are wanting to represent two or more persons in a matter, and it can be done provided we meet certain requirements that we'll talk about in more detail. And again, we'll look at a couple cases there that will help us see how that might apply. But first of all and foremost, I think for this part, is the 4-step model regarding the conflicts analysis. And again, we're talking about Rule 1.7 in Wisconsin, Supreme Court Rule 20:1.7, and in particular, comment 2 as we look at this. There are 4 steps. First of all, it's really important to identify the client or clients. And that can be something that's extraordinarily simplistic, or it can be something that's extraordinarily complex. And it's one of the things, though, that's really easy for us to skip over and not have any real clarity about what that is. And it's one of the easy mistakes that lawyers make simply because it seems so obvious that we don't give it adequate consideration. Second, once we have determined who the client or clients are, then we have to assess whether or not there's a conflict of interest, and that may present itself in the form of direct adversity, that the representation of one client is directly adverse to the representation of the other. Or secondly, that the lawyer's representation of one or more clients is materially limited by the lawyer's duties to another client, a prospective client, third person, or the lawyer's own personal interest. Third, once we identify whether or not there's a conflict, and assuming there is one, we may still be able to engage in the multiple party representation, provided we meet 4 requirements we'll talk about later. But there are some representations that are not waivable or not consentable, such that the existence of that particular kind of conflict of interest could never be waived. The lawyer may not represent the parties together. And finally, the issue of getting a waiver, if it is possible. We'll talk about what is required for a waiver, what is informed consent, and we'll look at some examples of when we've had adequate waivers and when we have not. First of all, identifying a client. This is something that's not defined for us in the rules, but it's a matter of agency law or contract law, and the restatement on the law governing lawyers helps us to understand this standard a little bit. First of all, it's a contract. And so there has to be an agreement by both parties, but it's not quite as strictly interpreted with regard to forming an attorney-client relationship as it might be in other contractual matters, and we'll see that in just a second. So on the one hand, a person is seeking and intending that the lawyer will provide services, and second, the lawyer will agree and manifest that consent. The issue arises when it's not clear. And if the client has a reasonable expectation that the lawyer is going to provide services and the lawyer does not clarify that, then the courts will determine that there is an attorney-client relationship. So one can be formed without the lawyer being fully aware that the relationship has been formed. The rule, although it doesn't tell us what is an attorney-client relationship, sorry about that, it does talk to us about some of the different situations where this gets a little bit complex. So we'll take a look at several examples. With regard to organizations and the constituents of organizations. So we're talking about anything from, a multinational corporation to a nonprofit organization. It can be a partnership, any kind of business relationship, LLC, LLP, or whatever. When the lawyer represents the organization, the lawyer represents that organization acting through its duly authorized constituents. Well, that's great. So I know who my boss is. I work for the organization. And I spent 16 years as an Army JAG, and so we were told that our client was the Army, acting through its duly authorized constituents. So armies are very complex organizations, and many of our businesses or other organizations we deal with are also complex. And so we can say we represent the organization, and that's true. But it's important for the lawyer to be clear about that. Am I representing the organization? Am I representing the board of the organization? Am I representing the CEO of the organization or the executive director of a nonprofit organization? Exactly what is it? And if it's a partnership, do I represent the partnership, or am I representing the partners individually? And that can be important too as we take a look at some of these things. To make it even more complex, in many of these situations, the lawyer is a member of the organization in some capacity. Might be on the board, might be more than just house counsel. Might have some financial interest in the organization, and so that then creates some potential for material limitation conflicts based on the lawyer's own interest and some other conflict issues too that we'll get to. Now, with regard to organizations and affiliates, the restatement gives us a little.
Dodge, I'm going to interject for just a moment. We're getting a little bit of feedback on your end. Your mics are hot, just to remind you of that. I apologize for interjecting. So I think that something just bled through a little bit on your end.
Switch the source code, that was the problem.
I'm sorry, say one more time, please.
We switched the source, that was the problem.
Okay, very good.
With regard to organizations and affiliates, we have some help from the restatement that talks about, helps us define that a little bit more. So the fact that I would represent a corporation doesn't mean that I also represent an affiliate, but we have to be careful of that also, because some of the things we might do representing a client adverse to an affiliate, to an organization we represent, there could be some adverse effects of that litigation or transaction that would affect our organizational client. So we have to be careful about that. There are some other situations too that are somewhat complex. We have to think about this insurance situation, because typically we know that when we get car insurance, the contract will provide that the insurer will provide counsel for us if we're ever sued as a result of an accident with the car. And so we have to be careful, if we're the lawyer hired by the insurance company, that we know the scope of our representation. We certainly understand who's paying our fees. And there can be issues of coverage with the insurance contract that'll arise and create conflicts, and there may be some other issues regarding settlements that would also result in different objectives between the insurance company and the client, the insured of that company. And so different states have different rules on that. In Wisconsin, we have some guidance in Rule 1.2E, 20:1.2E, that talks about the fact that the scope of the representation needs to be clear. It can be done in the contract of insurance. Second, we need to also take a look at 1.8, I think subparagraph F, which talks about third-party payors, which the insurance company would be in that circumstance. Governmental entities may have regulations that define who the client is. I mentioned just briefly my experience in the Army. Our regulation made that very clear. Other government entities may have different kinds of regulations that talk about who is the client. And finally, prospective clients, probably the most easy one for us to overlook, because it's very easy for a lawyer to have a prospective client and to have duties of confidentiality and potentially loyalty to a prospective client, even though no attorney-client relationship ever existed. And that can materially limit the representation of a current client or some other future client that may want to represent. So now, as we've taken a look at step one, who is the client? It's important to remember that we should be anticipating conflicts from the very beginning of the contact all the way through the end of the representation. And certainly lawyers should have good screening in place. There should be measures to identify not just the names of clients, but other interested persons or organizations. and to do that screening before the lawyer accepts any significant information relating to the case, anything that could be substantially harmful to the person providing it if the lawyer were to end up on the other side. In addition to that, we have to remain wary during the actual representation because there can be changes in parties, there can be changes in affiliations on both sides of a case, there can be new people coming into a transaction that you're working on, and so those kinds of things can raise conflicts after we've done our screening. So it's important for us to remember to be alert throughout the entire representation. Step 2, determining conflicts, is applying Rule 20:1.7A1 and A2. A1 talks about direct adversity, and A2 talks about material limitations. So we have here the definition of direct adversity, representation of one client directly adverse to another client, and you can see some examples there with one contrast on that slide. Material limitations are a little bit more fuzzy because you don't have that direct relationship to be looking at. Instead, you're going to have to analyze a situation that may relate to several factors, and the analysis is going to vary depending upon what those factors are. The definition we see in Rule 1.7A2, that there's a significant risk representation of one or more clients would be materially limited by the lawyer's responsibilities to any number of entities. Now, when the lawyer is thinking about this, the lawyer should be thinking about some very specific responsibilities that may be affected or materially limited. They include loyalty, confidentiality, communication, and independent advice. And we'll see these a little bit as we go through, but loyalty means, how does this affect my relationship with my current client or the other person who would be involved in this transaction or in this litigation? Is that client going to be comfortable giving me confidential information? Are we going to have the kind of free interchange of information that the lawyer needs to do a good job representing the person? Or is it no longer going to be a safe place because that information could be used to the advantage of the other side in the matter or someone else in the matter? Confidentiality and communication kind of run together because what we see in multiple representations frequently is the situation where the lawyer has confidential information from one client. It would be useful to represent the other client, and now there's a conflict because you cannot disclose it on the one hand, but you must on the other. And so at that point, you have a material limitation. And the last one is independent advice, and it relates to loyalty very clearly, but it means this. The lawyer has to be free to consider, recommend, and carry out alternatives that would advance the interest of each client. So if the lawyer is foreclosed in considering an alternative because it would be harmful to another client or to a third person or to the lawyer, then the lawyer has a conflict based on a material limitation. You can't pull your punches in representing your client because you have some interest in protecting another one or yourself. And here are some examples of the situations for material limitation conflicts, and they occur all the time. You can see there's quite a variety, and these are just examples from the comments. They arise in a lot of different situations in litigation or otherwise. So let's talk about litigation for a few minutes. If you're representing opposing parties in the same litigation, Smith versus Jones, and they're both your clients, that is a direct adverse conflict. It is non-waivable. You might be, on the other hand, representing co-plaintiffs or co-defendants, and so they're on the same side of the V in the case, so it's Smith and Jones, versus Wilson, and in which case you could represent Smith and Jones in some situations, but you can have directly adverse conflicts even in that situation. There may be a limited pot of money for recovery, and so the issue then arises, do you give it to Smith or Jones, dollar for dollar? There can be discrepancies in the parties' testimony, settlement strategies, settlement objectives, and so these things can arise even though you're actually on the same side of the case, at least in the form of the case. You can have directly adverse conflicts because of inconsistent legal positions, and while this can normally be done, you would have a limitation if the decision for one client would create a precedent weakening the position of the other client. There are a lot of considerations here, and I've listed some more of them in my outline, but generally it's okay if you're different tribunals, different times, different clients. because the time factor is important because of the effect it may have or would not have. And different tribunals relates to the idea that precedent in one jurisdiction may not be controlling in another, but that's the relevant consideration there. Okay.
Heath, I'm really sorry to interject. I'm going to pause for just a second. I heard a noise. Yeah, go right ahead. Give it a shot. I'll call over there while you're talking.
All right. Okay.
We're still with you.
You're still with me? Can you tell me where I am?
We were getting to the end of duties to report.
There we go. There's where we were. All right, good. There are some other situations where there are material limitation situations, just some general considerations, then a couple other examples. Representing the buyer and a seller in a particular transaction, that would be something that would be directly adverse. If you're forming a joint venture, a group of people come together and say, we want to put together a business, and they want to form a partnership or form an LLC or a corporation, then you would have to then consider exactly who you're representing. And typically in Wisconsin, under the Jesse versus Danforth case, the lawyer in that situation would represent the entity that's being formed rather than the individual constituents. And that's how we look at it in Wisconsin. It's consistent with the rule that talks about organizations where you represent the organization through the constituents. But we also then have to be careful that with regard to our interactions with the constituents that we're treating them all the same, that we're communicating with all of them and we're not representing any of them personally. All that would have to be very clear, and it should be in writing just to make sure everyone is good. Sometimes it's just not a good idea. Sometimes these groups come together, they want to form something and it sounds like a good idea and they haven't talked through all the details, and as we work through the details with them, we realize that there are some significant issues, significant disputes, and so we get in a situation where we can't represent any of them, and the actual entity may not then be formed, and we may not be able then to represent any of them in any dispute that arises after the entity fails. Other situations, wills for family members. I'm always wondering what happens when a husband and wife come in for a will, because so many things happen in our world that you have to be careful in those situations, even though it can be done. It should be done with a waiver with the two family members. And we talked about some of the others. I want to move on to some of the examples in the second part about representing multiple parties and taking a look at some of the situations where we're applying this model. We would, under step 3, look at whether representation is permissible, and then in step 4, we would be obtaining informed consent, and then having that in writing, and in Wisconsin, informed consent must be signed by the client. So we'll take a look at the examples because I think that will help us a little bit. So as we take a look at concurrently representing clients with conflicting interests, there are reasons why we want to do it, reasons why we shouldn't. We'll take a look at applying the 4-step model and look at some examples of things that worked and didn't work. So the advantages of representing more than one person are very simple. We want to avoid costs of additional attorney's fees. So if we could all have one attorney do it, we're going to save some money. Also provide some ability to resolve some minor disputes and work out some things in negotiation with the clients that wouldn't require additional work, additional lawyers being involved, and perhaps in addition to more expense, a lot more time, and maybe not as much ingenuity and dialogue in resolving the problem. A lot of dangers, though, because these things can blow up. So one of the most important things is that when we're representing multiple parties in any kind of a joint venture, this idea of communication and confidentiality is really at the front. We have to be clear with everyone that what we're sharing with one, we're sharing with all. And none of them have a right in this kind of relationship to say, I'll tell you this stuff, but you can't tell the others. And once that happens, you've got something that is a material limitation, is essentially unwaivable with very few exceptions. The one exception in the comment relates to trade secrets. So different companies can have joint representation, and they could mutually agree to protect each other's trade secrets. They could tell the lawyer, but the lawyer would then not share that. But in most situations, when you get the request, keep this from the others in our joint venture, the answer is, I cannot. It must be clear when we begin the representation that I will not. And then you would end up having to withdraw and have them find separate representation. in those situations.
We're going to try one more workaround, and once again,
Multiple party representations, we'll take a look at when it's permissible and when it's prohibited. And the 4 steps for when you get to whether something that is a conflict, you can still take on the representation, are these 4 ideas. You can provide competent, diligent representation. Law doesn't prohibit it. No assertion of a claim by one client against another client. We'll see some unusual ideas about this. And then the informed consent confirmed in writing idea. So the first question, can you provide competent and diligent representation? So Centra v. Estrin is a case where Centra is suing Attorney Estrin and his law firm for a breach of fiduciary duty out of a conflict of interest. The firm had been representing the city of Detroit and Windsor, and they had been representing Centra for many years. And they had never actually come into a situation where they had a conflict of interest. But Centra Incorporated was a construction company that wanted to build a second span of the bridge that goes between Detroit, Michigan, and Windsor, Canada, Ontario. And so there was a lawyer there working with Centra, and they were working on these plans. They had staffed them with the U.S. Army Corps of Engineers. They had gotten everything together, and they were seeking approval from the city of Windsor and the city of Detroit. And when that happened, the city of Windsor decided that they wanted to oppose the project, and they had been represented by David Estrin for many years, so he was their lawyer. And when they found out, when this hit, they found out that Windsor was opposing the fundraising, and Centra was doing the fundraising, and the lawyers for both parties were in the same firm. So that's when everything blew up. So they sued in federal district court for this tort for having a conflict of interest, and the federal district court dismissed the case on the ground that since both parties kind of knew the firm was representing them in some capacity, that it had been waived and there was no harm. The Court of Appeals for the Fifth Circuit said otherwise, Sixth Circuit rather, I'm sorry, and they thought that this, first of all, presented something that was a situation where the lawyers in the firm could not competently represent both sides. They have fundamentally antagonistic interests. They're once for the project, once opposed to the project, and it was just something that was really too directly adverse to be waived at all. In addition to that, the fact that the clients know that there's a conflict is not sufficient to say the clients waived it. Even though these clients are very sophisticated, they all had other lawyers working for them in-house, and they could certainly understand the problem with it. Of course, it's somewhat facetious to argue there's an implied consent when you're being sued by one of those clients for the conflict of interest, so there obviously was not an adequate consent, and there was no written document notifying them what the potential problems would be in providing informed consent. The second idea here is that the representation cannot be prohibited by law. So think of a case where you've got, you're representing 2 criminal defendants. They are both charged in a capital murder case, and you're representing both of them. And some states will just say, as a matter of law, you cannot do that. I mean, the conflicts of interest that might arise in selling one to save the other are just so strong and so important to protect that we're just not going to let that happen. Even if they both waive it, we're just not going to do it. In some circumstances, there are representations that are prohibited by law. So lawyers who work for the government are going to have limitations in many states and in the federal government from representing parties in circumstances where they had some official function. So with regard to the federal government, there would be like a 1-year bar or a 2-year bar from representing anyone in any circumstance that related to the agency where the lawyer worked. And so because there would be inside information and the government is not waiving that kind of a conflict, and it's handled by statute, state or federal statute. The third thing that we have to look at is whether there's an assertion of one claim by one client against another client in the same litigation, and this can occur in a couple of different ways. So in the Osbond case, it's really kind of interesting because the husband's lawyer wants to get the wife's mental health records, so sends a request to the treatment facility, and the lawyer for the treatment facility is the husband's lawyer's partner who turns over the records. Okay, now he's not a party in the case, but there is a claim now for these records in the case, and the lawyer representing the custodian of the record now has to respond to that. Now, they would normally be confidential without some court order, and the law of Alabama I'm not sure of, But in any event, they go to the husband. Now, the wife is mad, so she files a complaint, a motion in the court, divorce case, wanting to disqualify the husband's lawyer for doing this. And the judge looks at it in a quite interesting way. And I think the real concern is the unfairness to the wife, who had nothing to do with this request. But the lawyer for the husband's disqualified because there's a conflict where there's a claim by one client against another client because of the imputed disqualification of the two lawyers in the same firm. So that lawyer was disqualified in that circumstance. And the waiver implicitly there would not have been adequate to deal with that. Another example is the Vinson case where the lawyer's fee agreement explicitly says that he represents the husband and the wife in a divorce. Now, this is one of those step one issues, who is my client? So when you're thinking, who is my client, and it's husband versus wife, you're on both sides of the V, you're directly adverse, it's non-waivable, and it's also completely unnecessary. It's just a matter of not really thinking about who is my client, step one. But once you get there, the conflicts are pretty clear. Now, after this had occurred, and the husband, of course, had no involvement in this, never talked to the lawyer, looked at the marital support agreement, signed it. Later on, he thought, this really isn't fair to me, and then challenged it. And he hired counsel. They moved to set aside the marital support agreement, and the original lawyer who represented both of them continued to represent the wife in the motion. Of course, still with that former client issue there. And so the court not only disqualified the lawyer, but affirmed sanction for costs because the lawyer continued to represent the wife on the motion in the face of a conflict where there was a claim by one client against another client in the same litigation. Now, the last issue here is whether each client gives informed consent. And again, we talked about that Centra case with the bridge across between Windsor and Detroit, where just the fact that the parties knew about it doesn't mean that there's implied consent and it's not an adequate waiver, and there's no implicit waiver under ethics rules. The Iowa case, and Attorney Klaus, is really kind of interesting. It's a creditor-debtor case. So the creditor comes to Klaus and says, I need you to collect a debt against the debtor. He goes to the debtor to collect the debt, and the debtor tells him, well, I've got some claims that I can make in order to get some funds, and then maybe that can be used. And so the lawyer decides he can engage in a multiple representation against one client with a claim against another client, but he tries to get consent. And his consent is a 3-sentence email to both parties that says, we all agree that I can represent both of you. I'll help one collect money, and then that'll help the creditor who's owed money. As things go, he is able to help the debtor collect some money, takes his fees, gives no money to the creditor. And then, of course, the creditor is upset and files a grievance, and he has an impermissible conflict with really no waiver. A 3-sentence waiver that just says, yes, we understand I'm going to represent both of you, and you agree, was in no way implied or informed consent. And you have to take a look at the specific circumstances here in any of these situations regarding whether these 4 factors for permissible representation will apply, and the comments give us some very good information about that. Last, I wanted to talk about some advanced waivers, and really, anytime you do a conflict of interest, you should be identifying this at the beginning of a representation. So,
Didn't allow you to hit the button.
are we back? Can you hear me in Dodge County?
Yes.
Okay.
Great, good. All right, wonderful. We're just finishing up the conflict information. I'm on the slide starting with the adequate advanced waiver and the Visa versus First Data case. And 2 examples, and then we'll talk about some ideas for when this works and when it doesn't work. First Data was a company that was doing financial transaction processing, and Visa, we all know, is a credit card company. And they moved to disqualify Visa from a firm because they had been represented by the firm in other matters. What happened here is that First Data wanted to retain the firm, and when this happened, the firm said, look, we represent Visa, and we know you're involved in the same kind of business. And so we want you to know that we need to protect our relationship with Visa, and we are going to require, in order to represent you, that you waive any future conflict we have with Visa, which might include litigation where Visa is suing you. And this was all clearly spelled out in an agreement, and it was reviewed and negotiated with First Data's House Counsel, and they had a team of lawyers working there. What happened after the firm started to represent First Data was First Data then offered a new financial product which was designed to enhance their interests at the cost of funds that Visa would otherwise obtain in these financial transactions. Now, these guys at First Data had to know they were doing this when they hired the other firm. So it smacks of the idea that they're trying to disqualify the representation of Visa in the future. But within about a month, they launched this new program, and within a year, we're in the federal circuit in a lawsuit and a motion to disqualify, which I think everybody anticipated once they found out the new product was out. The court upheld the waiver in this circumstance for a couple of very important reasons. It identified Visa as the future adverse client. It informed First Data that it could include litigation and adverse litigation against First Data on behalf of Visa. And it offered screens and some adequate protections which had been honored, the court found in this circumstance. We can contrast that with an inadequate advanced waiver in the WorldSpan case, where WorldSpan sought the firm's representation in 1992. They had gotten a prospective waiver, and they had consented to adverse representation. But this situation is a little bit different for a couple of reasons. First of all, WorldSpan was doing work relating to airline reservations, and the firm had concerns because they represented several airlines, including American, Delta, and United, which I suppose in its own sense could present its own conflicts of interest from time to time. And so WorldSpan was advised that they represented the Sabre Group, but they did not provide the identity of the Sabre Group as a future client that could have an adverse interest. In addition to that, there was a significant passage of time. And so the court considered the fact that it would be hard to specifically delineate and anticipate conflicts that far down. And so for those two reasons, the failure to identify the client, the passage of time, there was a failure in this waiver, and the firm was disqualified from representing the Sabre Group. Okay, I want to skip over the intermediary language. The rule was deleted several years ago, and I think the issue here is that anytime a lawyer is acting as an intermediary, you have to look at the conflict of interest rule in 1.7 is the real, I think, significance of that. I want to move to the other outline here quick. Our next topic, duty to report professional conduct. But to summarize our conflicts information, we are looking at situations where we're applying a four-step model regarding identifying the client, determining whether there's a conflict based upon direct adversity or a material limitation, analyzing whether a conflict might be consentable or not, if you can provide competent representation, if it's not prohibited by law, if there's no claim by one client against another client, and you have an adequate waiver of it in those circumstances. And of course, with regard to waivers, there's one, I think, important thing with regard to the waiver. Informed consent is very specific, but to summarize it, a good rule of thumb is to say that when you're providing informed consent on a conflict waiver, the client should fully understand why it's not a good idea. And if they consent under those circumstances, then I think we have a good idea of how to start. Bill, I've got to move something here. I'll see if I can do it.
Yes. There you go.
There we go. Okay.
Did you click on it?
There we go. Okay. And so I want to move to our second topic, which is the duty to report professional misconduct. This is something that comes up, I think, quite frequently in our practice, but very infrequently in lawyer regulation. Wisconsin has no cases for violating Rule 8.3 on the duty to report professional misconduct. But when I talk to my colleague Tim Pierce at the State Bar Ethics Hotline, he deals with this on a weekly basis, he tells me. So it's something that you should consult with Tim Pierce or his colleague Aviva Kaiser about when these situations arise, and they do. And I remember in my practice before coming here, there would be many circumstances where we would have to consider whether this was something that had to be done. Right. There we go. Just to give you a couple of references here, they're there for you in my outline on my slides, but we don't need to talk about them. These are the questions we're going to address in the time we have left regarding duty to report professional misconduct. And we'll go through these quite quickly. I think we're about 10 or 15 minutes out, so it'll require us to move through this pretty well. The restatement is really very similar to our Rule 20:8.3, ABA Model Rule 8.3a. And so you can see it on the screen. We'll talk about each of these elements as we go through slides together. So essentially, what is the duty to report? It is a duty that is to report the professional conduct of another lawyer, and we'll distinguish this in a minute. And the model rule talks about reporting conduct of a lawyer and reporting conduct of a judge, and there are some exceptions where this would not need to occur. The duty arises because we are a self-regulating profession, and so we police our own. And we also recognize that by virtue of our professional knowledge and expertise and role, that we're going to be serving people who may or may not know that their lawyer is doing something wrong. And so it helps to protect the public in a significant way. When must a lawyer self-report? Now, that's something that's not required by 8.3 or the restatement. The ethics rule itself does not require a lawyer to self-report, except for one kind of tangential way that we'll talk about in just a minute. On the other hand, lawyers would have a duty to self-report under the law of their particular state for any of the reasons that are listed there: a conviction of a crime, professional discipline in another jurisdiction, or judgment for malpractice. In Wisconsin, a lawyer must report to the Office of Lawyer Regulation a plea of guilty or a conviction of any crime. They must report public discipline received in another jurisdiction. And those rules are 21.15 sub 5 and 22.22 sub 1. In Wisconsin, I know of no requirement that a lawyer report a judgment for malpractice, although some states will have this requirement. And there is a tangential exception, and that's the Rivers case. Rivers is a guy in a firm who his partners have asked him to poll a jury, contact them, and at the time, this is a case from the 1980s, it was contrary to South Carolina law and their ethics rules, and he assisted his partners. He was disciplined for failing to report the conduct of his partners and himself. And the theory here, in my mind, is very simply that because he was part of the misconduct, he could not fail to report the incident simply because he was involved. So even though it reflected on him, there is somewhat of a duty to self-report if you are involved in the conduct and other lawyers are also involved in the conduct. Next, I wanted to address what is sufficient knowledge under the rule. And the rule talks about actual knowledge. And certainly we can infer it from the circumstances. The courts are going to assess this on an objective standard. The fact that I suspect a lawyer has committed a violation doesn't create some duty on my part to investigate that or to inquire any further. But whether or not I have adequate knowledge is something the courts then would infer from the circumstances. And a good summary rule that we see in the cases is this: would a reasonable lawyer have a firm opinion the conduct more than likely than not occurred? Okay, and so a couple cases. Attorney Yu is an attorney in Mississippi who is hired by a client to sue former counsel. PFL is Pulmonary Function Labs, and they did lung tests related to asbestos damage. And when they did these tests, they would make referrals of clients to Attorney S. And Attorney S then would give them a percentage of whatever claim he recovered on behalf of the client. This was an unwritten, informal agreement which Attorney S decided to dishonor, and maybe for very good reason, and maybe because it never really existed. But when this happened, PFL decided to hire Attorney Yu and sue Attorney S to enforce the contract and get the payments. So there were some negotiations. Attorney Yu threatened that a grievance would be filed against Attorney S unless he negotiated in good faith and agreed to really an exorbitant fee. But the fee arrangement violates our ethics rules from beginning to end, so they really couldn't agree to that. Attorney S declined to pay, and he said he would not acknowledge the agreement. He neither confirmed nor denied that the agreement existed. He just said he was not going to acknowledge the agreement. And so Attorney U is in a situation then where he has his client telling him there's an agreement, evidence of payments that were made, but the opposing party is denying the existence of the agreement and repudiating it. So when this all came to a head, DFL had filed a grievance against Attorney S for failing to honor the agreement. Attorney S grieved against Attorney U for threatening the filing of a grievance in order to negotiate the dispute, and Attorney U did not file any grievance at all. So when this got to the disciplinary authorities, they took a look to see exactly what did Attorney U know. Did he know that there had been an unethical fee agreement? And so they looked at his knowledge to understand that, on the one hand, his client had given him information, but on the other hand, the opposing party would not acknowledge it. They applied a reasonable lawyer standard, the firm opinion standard, and they said the fact that this is disputed between the parties is enough for us to say the knowledge requirement was not met. He didn't have sufficient knowledge to know there had been a violation, and then he didn't have enough knowledge to require him to report professional misconduct. The Skolnick case is an interesting twist on this because in Skolnick, the firm fired him. They filed a grievance against him with the Illinois disciplinary authorities, and Skolnick then sued the firm and the associate in the firm who filed the grievance for defamation. And then this case then involved litigation that was covered by a protective order for discovery because the attorneys in this old firm are suing each other. There's misconduct going on in the firm. There are client confidences and privileges being protected. So all the discovery is occurring under a protective order. Through discovery, this associate who had originally reported Skolnick for the grievance finds out that there's more unethical conduct going on. So she goes to the court and asks the court to allow her to report it to the Illinois disciplinary authorities, and the court says, no, you may not. The protective order stands. When this is appealed, the Illinois Supreme Court says, well, wait a minute. When they looked at it in camera, they thought that a reasonable attorney could conclude that this misconduct more likely than not occurred. And so they thought then there was a mandatory reporting requirement and that the trial judge erred by not allowing it to be reported to the Illinois authorities. And so you couldn't use this protective order as a means for getting around the rule. Reelman is a notorious case from Louisiana where a prosecutor had concealed some exculpatory blood evidence and confessed on his deathbed to his partner in the office at that point that he had done so. The partner did not report it for 5 years. The accused was on death row, and they found out that the report had been suppressed. At that point, Reelman decided to tell the defense. He still did not report it to the Louisiana disciplinary authorities. He was suspended for a year for failing to report that when he had discovered it. The court looked at knowledge there in that case too, and they thought it's an objective standard. But when you look at the case, you really see that they measured that objective standard by statements that Reelman had made about his subjective belief. And so I was a little bit taken aback by that until I interpreted it in the way that the objective standard is a standard that applies. But if I can also prove a subjective belief of the attorney that the misconduct occurred, that also will meet that objective standard. It's evidence that can be applied when they review it objectively. Because Reelman had testified that he did believe misconduct had occurred and that he had some reasons in his own life why he wasn't responding properly, but he normally would have reported it. So he kind of conceded he knew everything he needed to know. Who is the other lawyer you must report? It can be a partner, even if you're involved, the Rivers case. It can be an associate. It can be a suspended lawyer. A couple cases where suspended lawyers are seeking to practice somewhat surreptitiously, and another active lawyer is aware of this, renting space from the suspended lawyer or being solicited by the suspended lawyer due to report even though the lawyer is suspended. In the Reelman case, he did not report a deceased lawyer. Really odd in my mind because once a lawyer is deceased, we lose jurisdiction. He has gone on to a higher authority. And so there's nothing we can really do with that information anyway. But Louisiana imposed the burden in that circumstance. Now, we've talked about knowledge and who is the lawyer. Just a couple minutes on the rest of this. When is the misconduct serious enough? Because not every violation has to be reported. First of all, it must be a substantial question, not substantial evidence, but it must be substantial as it relates to the seriousness of the misconduct. And second, it must be a relevant question. It must relate to the lawyer's honesty, trustworthiness, or fitness in other respects. And a couple examples for you on the slides. To whom must the report be made? That is very clearly, unilaterally, the disciplinary agency in the jurisdiction with authority for professional discipline of the license. Reelman's a good case and example. Telling the defense team is not enough. Lefkowitz, the language is very clear. They had to report it to the disciplinary agency. Filing a suit, not enough. Reporting it to the court where you're litigating, not enough. Forming the lawyer's assistance program, not enough. There's some latitude with regard to when the report must be made. The rule does not say when, and we typically look at the conclusion of representation because we do not want to interfere with the litigation. We do not want to adversely affect the reporting lawyer's client's interests. So Comfort's a good case. The CCDC is the Cloud County Development Corporation, City of Concordia, happened to be represented by partners. And of course, generally not a problem until they're both interested in developing the same land. And so one partner goes to the next office and hands the other partner a request for public records demanding to know the Cloud County Development Corporation's valuation of the land. So there's a conflict. The Cloud County lawyer recuses. Cloud County gets another lawyer named Comfort, who then threatens the city's lawyer with a grievance if he doesn't withdraw the public records request. And then that lawyer does. And the issue is whether the Cloud County lawyer, Comfort, had reported it to the disciplinary authorities when he should. Now, when he sent this threat to withdraw the public records request, he sent it to everybody in the county government, everybody on the board, everybody in the city. So he had publicly made these accusations but didn't report it to the disciplinary agency. He did, however, report it to the disciplinary agency within a couple weeks. Not a problem. And so the court found no violation there for that reason. Anderson was the chair of the Vermont Disciplinary Board. At Thanksgiving, he learned his partner was taking money from the trust account and did nothing, said nothing. 9 months later, his trust account manager told him it's still going on, and then he reported it. 9 months was too long, and he was disciplined. Cantor was a criminal defendant. He was interviewed by a lawyer for the New York City Board of Education. And then Cantor said, you've got to suppress these statements. They were taken illegally. Why? Because that lawyer had a duty to report them to the New York Bar Association for discipline of me, and they didn't do it. So because they violated their standards, then you cannot use this as evidence against me. Of course, now, strategically, it would have given Cantor a tip-off as to what was going on in the investigation. So that's why it wasn't reported. So he thought he should get some value for that. The court, the Federal Circuit Court, said that yes, it had to be reported, but it did not have to be reported till after the investigation. And the judge in that case is weighing the interests of the criminal investigation against the ethical requirement to report. Okay, very quickly, there are some exceptions to this rule. 8.3C talks about confidential information, and that's very broadly defined. The general rule is that if reporting would require the release of confidential information, the lawyer should seek the client's consent and abide by the client's decision. There are going to be circumstances where it's more complex than that. We don't have sufficient time to talk about it. It's one of those things, though, that you should call the ethics hotline and talk to Tim Pierce about. The last issue is a case of Himmel in Illinois. They define the scope of this exception differently. In Wisconsin and in most states, we talk about confidential information, which is information relating to the representation. It's very broad, and it's much broader than the attorney-client privilege. In the Himmel case, and in Illinois today, they still define it more narrowly. The exception applies only if it's attorney-client privileged information. So if it's other information relating to the representation, other than that communication from the client, the duty to report would still apply. That court case still stands in Illinois. And then finally, there's an exception for lawyers who are working as part of the Lawyers Assistance Program and assisting other lawyers who may be impaired. And information that these lawyers who are part of the program receive does not trigger a responsibility to report to the disciplinary agency. So Wisconsin also has this. Wisconsin also has an additional exception for lawyers who are members of arbitration or mediation panels adjudicating lawyer disputes for firm dissolutions or transfers, issues that relate frequently regarding how to handle fees of clients that need to be allocated as a result of a firm breakup, sale, or partners leaving. Okay. And that
Wonderful.
concludes the pitch. Fast and furious, I know, but
Thank you. That
thanks,
was wonderful. Great. Thank you.